on in 1 hour time, not
Yeah, I
not
know.
at this hour.
I know. I'm very sorry.
So apologies.
No, that my apologies. Sincerely apologize for my mistake. So I was misled by Baidu. I didn't calculate the time lag. I'm sorry.
Yeah, no, that happened just I think 2 weekends ago. So you probably
Yeah, I
um,
began to
yeah.
arrange this event 2 weeks ago. So at the time was right, but now it's winter time. I think that's the problem.
Let's see.
Okay.
I will
Yeah, you begin
I
to
will
share
do
your.
well. This is part of the share of the presentation.
Okay.
I will also make sure that I'm in the picture. Um, no, I think I'm there.
Yes, yes, yes.
Right. So I don't even need to share the screen. It will simply work like this. But I guess everything is mirrored, right?
Mm-hmm.
So I
Yes,
need to
yes.
mirror back. Now it's right.
Oh, no, it's right. It's right here.
It's correct.
It's correct. It's correct. You don't have to mean it right. Mm.
Okay, because I see in my picture something mirrored, but you read correctly uh, what is on the slide, right?
Yes, it's correctly performed.
Okay, good.
Okay,
So if you
Professor
just
Sanders, uh, before we get started, could you allow me to give a brief introduction of you and Professor Tianxiang to the audience?
of course, and I also then will be ready. So go ahead.
Okay, thank you. 好，各位同学，非常抱歉啊，因为我个人的这个算时差的原因啊，刚才其实教授已经解释了，就是他们也是刚刚开始的这个冬令时，我在开始筹备这个活动的时候呢，那个时候还是用这个夏令时，所以在时间上面是有一点这个误差啊，相差了1个小时。下来呢，我就稍微简要的介绍一下这个我们这次的主讲人啊，我们的桑德斯教授。他的本科是毕业于河南的第二堡大学法学院，然后呢，后来在英国伦敦大学皇后玛丽学院商法研究中心完成了他的博士学位。那毕业之后呢，他就一直在马斯特里赫特啊，荷兰著名的高等学府任教。同时呢，桑德斯教授也是我们的老朋友，他是我们暨南大学法学院的客座教授，同时是多家著名期刊的这个审稿人编委。那何天祥教授Professor 何天祥你好。那么何天祥教授呢是香港城市大学的教授，同时也是 LM 项目的执行主任，也是多家知名国际期刊的编委会成员。那同时呢，天祥老师呢也是我们暨大的校友。另外呢，他在中国人民大学和马斯特里赫特大学拿到了双料的博士。所以这个天祥在读人民大学的时候呢，我们应该是同一年入学人民大学的，所以也是我在人大的同学。所以这一次呢，就有幸邀请到桑德斯教授和何天祥老师一起来参加这个活动。那接下来我们这个活动的主题呢是关于这讲座的主题是关于欧盟专利改革、统一专利法院和单一专利。那这样的一个统一专利法院和单一专利这个制度呢，其实早在上世纪70年代就已经开始倡议，但是一直呢就是进展不是特别的顺利。那其实早在2012年的时候，欧盟关于统一专利的这个欧盟条例就已经通过，13年也通过了这个统一专利法院的这样的一个协定。但是这个协定的生效呢，是要求有13个国家交存批准书，还有3个最多专利的欧洲国家包括德国、法国、意大利通过。那么在2021年的时候，随着相关的一些国家交存了这个批准书之后呢，那目前来讲呢，这个欧洲统一专利法院还有单一 专利的这个条例呢，是预计在2023年4月1号生效。所以我们这个讲座呢，是针对这个即将生效的统一专利的法院制度和统一单一专利的制度来进行一个解析应该说是恰逢其时的。Okay, Professor, I just gave a brief introduction of the background of this lecture. So please, let's present distinguished Professor Sanders to give this lecture. Thank you very much.
Well, thank you very much, and good day to you all. During this lecture, what I will try to do is give you an overview of the EU patent reform package, which will take effect officially as of the 1st of April next year, 2023. So this is apparently not a joke, not an April Fool's joke, but really we will have a completely new patent system in Europe, in the participating EU member states. And this is supposed to be a unitary patent system with a unified patent court, which is quite unique. What I will do is to give you an overview of the history of the patent system, leading to the inception of the European Patent Convention and the establishment of the European Patent Office, and how this patent system is now transformed in a truly unified patent court system, bringing hopefully a lot of harmonization in the future in patent practice. So where to start? Where to start with this story? I thought best to start with the first account of a type of patent system for innovation. And this was in fact in the ancient Greek city of Sybaris. This was a Greek colony located in what is now the southern part of Italy, where for the purpose of innovation and a system for innovation, a patent was awarded, and a patent then being an exclusive economic privilege if a cook invents a delicious new dish. So you can imagine that apparently these people loved to eat, and they also loved to ensure that there was an incentive system in order to get new delicious dishes. And you can see here that a cook then is granted a 1-year time-limited monopoly. And the purpose was also stated. During this time, the investor, only he shall reap the commercial benefits of the dish, and this will motivate others to work hard and compete. So it's a system of creating competition in the marketplace. Now, we also know that in the context of further patents for invention, the first patent for technological invention was offered by the city-state of Venice in 1474. So the statute at the time was that any person in this city who makes any new and indigenous contrivance not made herefore in our dominion shall, as soon as it is perfected so that it can be used and exercised, give notice to the state judicial office. In other words, in order to obtain such a patent, you needed to go to the Doge's palace. As you can see here, the Doge's palace depicted on St. Marco Square in Venice, and you had to convince the state judicial office that indeed you had invented something that was not available before in the city-state of Venice. And then you would be able to obtain a monopoly for 10 years. 10 years at that time being the period during which you could train 2 apprentices in a guild system, so master-servant guild system. And this, in fact, was very positive for Venice. They were dominant in shipping. They had the best ships, the best war industry, and also in terms of cultural industries, the Murano glass blowing factories were established also on the basis of such a patent. And you can see here that the patent for invention served as a means to drive domestic innovation policy. But patents also had a clear downside, and that is that they create monopolies. And monopolies, in essence, as you know, they work to raise prices, diminish consumer choice, have a negative impact on supply, and in essence, it frustrates the market because consumer demand is not serviced. Now, this is what led in 1624 in England to the very first statute of monopolies. And as you can see from the text here, all monopolies are abolished. All letters patent, as they were called at the time, were abolished. And this is in fact the result of a case that was that went up to the courts. Depending a bit on the pronunciation, it's the case of Darcy versus Allain, which involved a monopoly, a patent for the manufacture of playing cards. And when the patentee sought to restrain others from producing and importing playing cards, the court said, well, this is a very undesirable type of patent because it is unchecked and it is taking away from the public something that they are entitled to. They are entitled to more variation, more consumer choice and lower prices. So please, dear monarch, stop giving out these privileges. And you can think of patents to keep bees, patents that would give monopolies on the grazing of cattle, or letters patent that would allow certain captains of ship to commit piracy on the high seas to the benefit of the English crown. All kind of trade monopolies. And they were declared contrary to law, except for one, except for the patent for invention. And this is also expressed in this statute of monopolies in section 6, that letters patent related to new manufacture, in other words, new methods of manufacture, something that was not part of the state of the art before, something that did not yet belong to the public, so that it wasn't taken away from the public, something new could indeed be subject to a patent for the term of 14 years. But with a big caveat, such letters patent and grants should not be contrary to the law nor mischievous to the state by raising prices of commodities at home, hurt trade, or be otherwise inconvenient. Now this 1624 statute, and especially this language, is still of importance today. Just think about all the discussions on compulsory licensing that we've had in relation to SARS-CoV inoculations, right? So, in other words, patents granted, even if they are patents for invention relating to something new, should still not result to social harm. And this is how we view patents today. If we look at industrial property law and the place of patents therein, we see that patents are justified because they serve to create a market for technology and ensure that information is accurate in relation to information that is otherwise a public good. Public goods being characterized by the fact that they are non-rival and non-exclusionary if there were no patent right in place. In other words, I share information with you, you can share information with everyone. There is no scarcity. The information that I now convey with you is something that does not deplete. You can share it with others, and at no time is that information lessened. Now, when I have to make a commercial decision on whether to bring new technology to the market, something that is unprotected, I would not easily do so. I would not easily share that information if I didn't know that I could benefit from some sort of monopoly, even if it is temporary. And so the patent for an invention serves to create a competitive market for technology that otherwise would not exist. And as such, it functions as an incentive to innovation, much like the Sabaris patent for the new dish or the Venetian patent system. But there is a payoff. The payoff is, and this is what we call the social contract underlying the patent system, that one has to reveal the inventive concept in order to obtain exclusivity. Remember the Venetian patent system, you had to go to the Doge's palace, to the state official, in order then also to convey that information. And obviously we still have that. We still have patent offices where the information is indeed registered and assessed as to novelty, inventive step, and industrial applicability. Now, it took us quite some time, however, to move from patents being an instrument of national industrial policy to something that is seen as a universal social contract for mankind rather than the domestic market. If you look at the first US Patent Act, for example, only citizens could apply for patents, or people wishing to reside within the newly established states of the US. And because, of course, they had just fought a war of independence in order to break away from England, British subjects were charged higher fees in order to obtain a patent for invention in the US as compared to nationals or as to compare to other foreigners. So there was an element of discrimination. We also see the first French Patent Act sort of more or less operating on the same premise. And this changed fundamentally in the 1844 French Patent Act, where this social contract is first clearly articulated. Every useful discovery is, into Kant's words, the presentation of a service rendered to society, right? And in return, you can get exclusive exploitation of the new invention for a limited period of time only. So that also heralds in the new type of patent. However, just like the statute of monopolies, there were questions, lingering doubts as to whether the patent system would fulfill its function. And as a matter of fact, in Switzerland, according to based on the pressure of the chemical industry, there was a limitation on the subject matter that you could patent. So no patents for anything other than mechanical models. And in fact, the lobby is articulated as such. In the interest of general prosperity of industry and trade, patent protection, that cup of sorrows, meaning something very, very bad, sorrowful, may pass from us. The Netherlands, something similar happened. There was a privileges system very early on. So the old patents for economic activity, which, yes, the first patent granted related to an invention, but also trade monopolies for the India East Trading Company were subject to a monopoly right. And indeed, a patent for invention system was also established in 1817, but abolished in 1869. And this was once more due to the pressure of domestic industry. Unlike Switzerland, this was not the chemical industry, but the new electronic industry. It was in fact Philips industry that pushed for the abolition of the Dutch patents for invention system because they wanted to develop themselves. They wanted to be free to copy the technology, and their complaint was that all patents were held by foreign undertakings. Does that sound familiar over there in China? I think it does. It wasn't, however, until the Paris Convention, and you see both Switzerland and the Netherlands signed on very early, that there was a pressure also to re-establish the patent system. And this was done in 1907 in Switzerland and in 1910 in the Netherlands. But by then, the Swiss pharmaceutical chemical industry had already established itself and was able to grow. Much like in the Netherlands, Philips Industries was capable of producing technology that was also desired outside of the Netherlands, so was suitable for exports. So the Paris Convention of 1883 was really the catalyst for the creation of our current industrial property system. It was created in the aftermath of the great world exhibitions. So during these exhibitions, countries would show to each other how far they had progressed industrially. The Eiffel Tower was presented during that time in Paris. But there was, of course, an issue with demonstrating, showing your latest, newest inventions, because we, of course, recognize in our patent systems the need for novelty. And so the Paris Convention contains three basic principles to deal with discrimination: the national treatment principle, ensuring that discrimination is no longer the practice in the participating member states to the Paris Convention. Remember the differences in treatment in the US Patents Act, for example. So you should treat foreign nationals the same as you treat your own. The principle of priority, establishing in the context of patents that the date of very first filing in any of the member states to the Paris Convention is the date on which to assess novelty and inventive step. Also in other members states to the Paris Convention. And that for a period of 12 months for patents. And independence of rights, still recognizing the sovereignty of all nation states in order to determine whether a patent can be granted in the domestic legal order. I will return to these principles later on in order to also look at some of the aspects of the unitary patent package that we now have in Europe. Further harmonization, you know about this probably already, the Patent Cooperation Treaty, facilitating the international application and administrative process for patent filing through a single application, and also the WTO agreement, which possesses many of the same principles of the Paris Convention, which is imported by reference into the TRIPS agreement principles, but also allowing for dispute settlement in relation to the key provisions in the WTO agreement, minimum standards of protection and obligations on providing effective enforcement. Also, the brilliant invention of the WTO agreement is that we no longer need to deal with member states recognized by the United Nations. But we deal with customs territories rather than as members, rather than nation states. And so in the context of Greater China, this really gives the possibility to have different customs territories, mainland China, Hong Kong, Macau, but also Chinese Taipei in this respect. Okay, so they are all independent members to the WTO and can also benefit from the international system that is in place in relation to protection of intellectual property under the TRIPS agreement, the trade-related aspects of intellectual property rights. Within the regional sphere, however, there is also harmonization, and this is where I now want to focus. Regional integration in Europe / the European Union. Well, after the Second World War, there was a feeling that a lot of the European wars could have been prevented if there was greater economic cooperation, and that we didn't need to fight over resources. So the first coal and steel union that was established after the Second World War already dealt with these types of issues. How to ensure that everyone has access to scarce natural resources. And also the creation of a common market. So we have a single customs territory encompassing now 27 European nation states. In that context, it was also thought that we needed a convention for the European patent, for the common market, for this common customs territory. It was already drafted in 1973, but never fully ratified. The only thing that seemed to be possible at the time, in 1977, was the European Patent Convention, dealing with a system under international law, not European Union law, but international law, which would take care of the centralized application and grant procedure for patents. And after the patent has been granted by the EPO, the European Patent Office, it then fragments into domestic national rights. And if you want to seek protection for those rights, you have to address the national courts. The national courts are competent to deal with questions of validity and infringement. The centralized procedure at the EPO, therefore, only deals with the moment of application to grant and the period still available for a central attack of the validity of the patent, namely the opposition procedure. I will return to this in a moment. So this system is incomplete. It deals with the acquisition of patent rights, but not of their enforcement, harmonized enforcement, and subsequent questions of validity. So this is what the agreement related to the community patent system of 1989 sought to establish. It failed. And this basically had to do with a number of issues related to that very core principle of the Paris Convention, namely independence of rights. Because first, within the European Union, some issues had to be settled in relation to controversial areas, such as morality in relation to biotechnological inventions, where the countries did not see eye to eye. In relation to medicine patents and the administration thereof, but also questions on whether computer programs are to be protected by copyright or whether they can be protected by patents, and also certain aspects of intellectual property enforcement. So that is what over time has happened within the European Union in the context of EU directives. European Union directives harmonize the domestic laws in the member states. And we also have EU-wide law. Such are called EU regulations. Also dealing with some aspects, like, do we protect plant varieties under patent law, or do we have a separate system for the protection of plant variety rights? Now we do. Plant variety protection is available inside of the European Union through a centralized procedure with the Community Plant Variety Office, for example. We also have uniform rules to deal with supplementary protection certificates for patents related to pharmaceutical products, but also products where we need marketing authorization in relation to the safety of such products. So agricultural herbicides and things like that, where we may have patent protection, but where the patentee is not yet able to go to market and recoup the investment. Also, pediatric uses for medicine are stimulated separately at central level. So conversion of drugs that we know that work in adults but need to be tested separately for use in children. So probably it was only after these issues could be settled in EU law, in the EU context, that we could think of looking at a European patent system in a different light. And in order to do so, we must go back to the successful convention, which is the European Patent Convention of 1977, with this centralized grant procedure. As I said, this has established the European Patent Office and given it a role up to grant and opposition. Afterwards, these European patents, as they are called, have only national or domestic effect in the participating member states. And as you can see, these are not just European Union member states. These are also states outside of the European Union. What's more, we even have so-called extension or validation states. Just imagine, if you wish to obtain a patent in Cambodia, you can go to the European Patent Office and request that the European Patent Office assesses novelty, inventive step, and industrial applicability. Now, this is of huge benefit to a poor and developing country like Cambodia that is not willing to commit resources to establishing a patent office. After all, inside of patent offices, you seek to employ the best and brightest technical people in order to assess. Well, for a developing country, these people are much better placed in industry to make real inventions rather than work in a patent office. Apologies to all people working in patent offices, by the way. But yeah, it's a fact. So this is what explains the validation system. But ultimately, it functions along the lines of the Paris Convention principles. There is independence of rights between all participating member states. And so the patent procedure at the European Patent Office is this. From application to grant, there is an approximate time period of 4 to 5 years. But after 18 months, the application will be published. This is the social contract that I alluded to, remember? The social contract that all applications must become part of the body of knowledge of the prior arts. And it is then possible after grant for third parties to raise opposition to the granted patent. But upon grant of the patent, what happens in principle is that there is a fragmentation. A bundle of rights remains in each of the participating member states. There is a national patent, even if it is called a European patent, but it's still domestically enforceable and the validity is tested domestically. So the only opportunity to attack the validity of a patent centrally is during that 9-month opposition procedure before the European Patent Office. And if the European Patent Office's technical boards and technical boards of appeal decide that the patent is invalid, then it is deemed to never have existed anywhere. If, however, you attack the validity of the patent in any of the member states of the European Patent Convention, and that is a success, then the patent is only invalidated for that particular member state. And you still need to litigate in each and every other member state of the European Patent Convention in order to have the patent invalidated. And finally, one last thing, the European Patent Office operates in 3 languages: English, German, and French. And so you can apply in these 3 languages. But once granted, the practice is that for every national patent, there needs to be a translation. And this raises the cost of acquiring a European patent in multiple participating member states. So you don't get a central right, you don't get a unitary right, you get a bundle of national patents and you need to translate. And this explains the high cost of doing business, as they call it, in the patent field in Europe. But there is more. If we look at the way in which the output of the European Patent Office's case law is dealt with in the member states, you also then see that the influence on national courts may be present, but the courts are not bound by the EPO's jurisprudence. And whether they even refer these domestic courts to the case law of the European Patent Office differs from jurisdiction to jurisdiction. So the courts are in the nation states are in principle free to conduct business within their domestic legal system. They don't even have to look outside of it, which for the purpose of harmonization is not ideal. And even if there are decisions by courts in the selective EPC member states, even though the European Patent Convention harmonizes also substantive patent law in those member states, there is no consistency. There is a growing convergence, but there is no consistency on referring to other national decisions, and there is also an ongoing process of harmonization. Yes, there is convergence in relation to parallel cases on the same facts. And I've given an example in relation to the Permitrex decision, where things already went much better than in the classic Epi-Lady cases, where we had greatly diverging decisions on exactly the same patent with exactly the same parties and exactly the same circumstances. In other words, for the European Union, this is a great problem because you have, in principle, a unified customs territory, but you have different legal outcomes. And so this brings me to the next step, the Unified Patent Court and the European patent with unitary effect. This is the system that will become operational next year, 1st of April. So the unitary patent package has been agreed to by 24 EU member states through a principle called enhanced cooperation. In other words, according to EU treaty law, it is possible for member states of the European Union to enter into closer economic union. We already had this principle because the Benelux countries established a unified customs territory with a unitary trademark, Benelux trademark right and Benelux design right, even before the European Union came into existence. So enhanced cooperation between member states was already a possibility in relation to creating greater economic union. So you know that we started, perhaps you know, we started this project with 28 member states, with the United Kingdom still included, of course, before Brexit. But Spain did not want to be a member of this system because they demanded that Spanish be included as an official language. And the rest of the member states said, look, this is not feasible. It will increase costs. And in any event, if Spanish is to be included as a language, why not other languages where we have even larger populations like Poland? So why not Polish? In fact, the Polish government said, well, if Spanish is to be included, Polish should be included too. And the Italians then say, wait, we are also with so many million. Italian should be included too. So the compromise is, let's stick to what we know. French, German, and English. And by the way, if we create a unitary patent, we don't need to translate until there is a practical reason to do so. We only need to provide translation in case of litigation where a party wishes to proceed in the process of being able to defend or articulate in the local language. So no need for translation other than for the claims of the patent. Now, the United Kingdom left, although they negotiated, they co-drafted, they even ratified, and then they withdrew from the system after Brexit. Spain continues to resist. They don't want to be part of this system. Croatia is a new member state. They have not yet gone through the full process of signing on to all EU law. And so this is also one of those things where they can still do so. And Poland indicated that despite signing on, they will not ratify until they can see what the system does in practical operation. So we are left with these countries listed here, 24, and some in some countries the system will become active next year, and others will follow a bit later. For example, in Ireland, there still needs to be a referendum on the unitary patent package. So what does the package consist of? Because I use this word package, right? The word package comprises an intergovernmental agreement on the Unified Patent Court. This is the UPC agreement. And it establishes a specialized court to the participating states for the purpose of establishing and enforcing the unitary patent protection in all the participating EU member states to this system. And this comprises not only a European patent with unitary effect, but also all existing and future European patents and supplementary protection certificates. Although there is an opt-out system in place. I will get to that in a moment. And also, I already mentioned, the European patent with unitary effect is established by EU law through the regulations that I've listed there. the European patent with unitary effect, and the translation arrangements for the unitary patent. This is the enhanced cooperation system. And so we have a chimera, we have a hybrid, we have an intergovernmental agreement to which, according to the Court of Justice of the European Union, only EU members can be party. And we have EU regulations creating this European patent with unitary effect. Now, what is this patent with unitary effect? It is a patent granted by the European Patent Office. So, hence the title, European Patent. But rather than indicating at the European Patent Office which EPC member states you want to designate as countries where you want to obtain a national patent, you can now designate all the territories covered by the UPC agreement in one go. So you get a European patent, because this is a patent granted by the European Patent Office, with unitary effect. It is a single legal title in all the participating member states to the UPC agreement. Now, how does the court system work? Well, it works through courts of first instance that you can address. We have one regional division, which is the Nordic-Baltic division. And you can see it's a regional division because it encompasses a number of states: Sweden, Estonia, Latvia, and Lithuania. They are combining their local court into a regional division, which is seated in Stockholm. What is also new to this system is that you will see legal and technical judges sitting together when needed in order to assess the patents. And the system deals both with infringement and the validity of the patent in one go. And then we have local divisions seated in all of the participating member states. There are 13 in all. And since Germany has the bulk of patent cases, there are 4 local divisions in Germany alone: Düsseldorf, Munich, Mannheim, and Hamburg. For other countries, there is one local division. So these are in essence courts of first instance. And then there is a central division. The central divisions were supposed to be in Paris, in Munich, and in London, but since the UK has withdrawn, there is an open space. It may become Milan in Italy, but we don't know yet. The idea of the central divisions is that they provide an avenue for cases to be heard centrally, depending then, of course, also on who the owner of the patent right is, the patentee. Especially if you're a foreign undertaking, you may want to go to Paris, or you may want to go to Munich, and then you also know that there is a specialist division there, and this is determined by the so-called international patent classification system. So you see, for example, Munich specializes in mechanical engineering, lighting, heating, weapons, and blasting. So if your case is highly specialized, you may want to go to Munich. If it's human necessities or chemistry and metallurgy, this was supposed to be London, you may want to go to Milan in future. This is where most likely you find the specialist technical judges, right? And there the technical judge is always present, whereas in the local or regional divisions, you have to request for a technical judge to be present. Now, there is also a Court of Appeal, which is seated in Luxembourg. The composition is 3 legal, 2 technical. And then for all questions as to interpretation of EU law, you need to be able to refer the case to the Court of Justice of the European Union. So that is ultimately the final arbiter. And see here also the problem for the United Kingdom. After Brexit, they no longer wish to recognize the jurisdiction of the Court of Justice of the European Union, and so they could not be members to this system. The same goes for Switzerland. Switzerland wanted to be a member to this system, but according to a decision by the Court of Justice, couldn't. And so let's turn to the other element. Now that we've seen the court, let's have a look at the unitary patent. So according to Article 2 of the European Patent Convention, these are European patents. But also the European Patent Convention itself already allows for unitary patents. So the drafters of this system already anticipated ever closer union also in relation to patents. So this is the point of entry in the European Patent Convention for this system. And indeed, what we then also see is the official wording, and now we also see the references to the decisions creating the European patent with unitary effect and the agreement on the Unified Patent Court. It is now part and parcel of the European Patent Convention. So this is what we have already seen, the UPC overview, the graph. There is also, however, a possibility to request mediation or arbitration. And in essence, on substantive patent matters, the Court of Appeal, the UPC Court of Appeal, is the final arbiter. So the referral to the Court of Justice of the European Union, possible based on Article 24 of the UPC agreement, relates to those other issues where we already have some harmonization. The Biotech Directive, Plant Variety Protection, SPCs, computer program, IP enforcement, and so on and so forth. And what is also being worked on is now a unified system dealing with medicines and medicines approval, which is now still based on a country-by-country basis. Also, work at the European Commission is ongoing in relation to having one single system for compulsory licensing. So now the member states still are sovereign in relation to compulsory licensing. Now, the experience, of course, with SARS-CoV vaccines has been that this is undesirable to have such a fragmentation in the European Union. And so now, based on the Unitary Patent Court and Unified Patent Court and Unitary Patent System, there is an opportunity also to harmonize these issues further. Now, according to the UPC agreement, there is international jurisdiction for the UPC courts based on the Brussels regulation. And that means that, in essence, it is possible for the UPC, the court, to also deal with enforcement and judgments also in a cross-border setting. And I don't want to go too deeply in this because this is rather specialized, but just for you to know that this follows the Brussels regulation in relation to recognition and execution of judgments. And that then also has some effects on where to bring cases. If a member state has no local division, you go to the central division, etc., etc. The decisions are immediately enforceable in all of the participating member states. Well, this is all based on the so-called Brussels regulation. This also is true for provisional and protective measures, although you can still see in the last one may be available under the law of the member state. This is also where further harmonization is required. Lispendence rules, once more, I don't want to go too deeply in this. This is going too far for this lecture, but at least you see here the rules that are to be applied according to Article 71C of the Brussels regulation recast, and that also still has to be fit in the UPC agreement. And we'll have to see how this works, because there is an exception to exclusive competence. This is where it does get interesting. What is the competence of this unified patent court? And what is then left for the national courts? Where does it have, according to the agreement, exclusive competence, and where does it not? Now you can see that according to the agreement, there is a great deal of exclusive competence of the Unified Patent Court. So this covers all aspects, more or less, related to the patent's validity and the possibility for enforcement, including counterclaims, actions for damages, and prior use defenses. And you may then question, is there anything left for the national courts? And there is. There is in relation to disputes on pure contracts, unless they are raised in a counterclaim. So if you are being sued, the defendant then raises the issue that there is a contractual license and that they are therefore not infringing, for example. Issues of entitlement, I'll come back to that in a moment. Employer-employee relationships and remuneration rules for inventions, also not covered. And fair and reasonable non-discriminatory licensing issues, unless, once more, related as the defense in a counterclaim. You offered a friend undertaking and ultimately you didn't grant us a license, for example. Whereas you said that you would under fair, reasonable, and non-discriminatory terms. So still a lot left for the national courts. And then let's have a look at the unitary patent. Is that truly unitary? Well, yes and no. It has unitary effects, but where it comes to the recognition of the right as a property title, it is to be treated in its entirety and in all participating member states as a national patent of the participating member state in which, according to the patent registry, the applicant has its residence or principal place of business. So if the applicant is German, then it means that the question of ownership of the title is dealt with as a property title, is dealt with according to German law. If this happens to be a French applicant, then it's French law, and so on and so forth. If you do not have a residence or place of business in any of the participating member states, then it's the national patent of the state where the European Patent Organization has its headquarters. So it's German law. So for all non-participating member states applicants, including Spanish applicants, the law that governs their unitary patent as an object of property is German law. So this is a very, very interesting and a very peculiar situation. I understand, of course, it's practical, but it may also raise a number of issues in future. And then there is, to complicate matters further, and then of course I go to the final issues, there is the transitory regime. So if a European patent does not have European effect, you have to say so. You have to opt out of the system. So as of next year, you can apply for a European patent as a patent with a bundle of rights, or also as a European patent with unitary effect. The patent with unitary effect falls within the exclusive competence of the Unified Patent Court. But as I showed you also earlier, also all European patents already granted or granted in future will also fall within the competence. So is there anything left for the national courts? Yes, there is. You can opt out of the system. During a transitional period of 7 years, cases may still be brought before national courts. And if the cases are brought before the national courts, then you can no longer go to the Unified Patent Court, and vice versa. So that also means that there is an agreement that there should be a unitary of action, no fragmentation of legal actions in infringement or invalidity. And then it is possible for parties to withdraw from the system. And quite a number of corporations are now doing this, especially pharmaceutical companies. In relation to some of their patent portfolio, they say we would rather stick with the system that we know. And partly this is due to a level of trust. Let's see what happens before these new courts. Or it has to do with an issue of strategy. Because if you attack now the validity of a European patent with unitary effect successfully, the effect will be that it will be declared invalid in all participating member states in one go. Whereas in the past, as I mentioned, you had independence of rights of all the separate EPC member states, and that meant that there would still be a discussion. And also, these courts were not bound by each other's decisions. So you had multiple chessboards to play on, so to say, which with the Unified Patent Court system, you don't. It's convenient. One court, and you get your injunction immediately in all participating member states. But if it goes wrong, if your patent is declared invalid, you immediately lose your right in all those states. So you can understand perhaps why some corporates want to strategically use either system depending on what type of patent is concerned. So the opt-out runs for a period of 7 years and can be extended for another period of 7 years. We'll see what happens. I have to say, though, that now that the judges have been appointed, and they are really the top European patent judges, the faith in the system is very, very high, because, of course, that was also an issue. Do we trust that these courts will be properly operating? So the opt-out issues, they will arise, and also there may be conflicts between cases being brought before the national courts or before the UPC courts. When should a court then say, well, I'm not competent to hear the case? And it would seem, but this is not regulated, that then the UPC courts should prevail over any domestic competence issue. Okay, so this is more or less what I wanted to share with you. And I hope this has given you an idea of what is about to happen in the European market context. And if you have any further questions, of course, I'm quite happy to take them. Thank you.
Okay. Thank you very much, Professor Sanders, for your wonderful lecture. It's really clear and very informative. Professor Sanders started his lecture from the history of patent and the rationale of patent, and then explained why EU need a unitary patent system and a unified patent core in detail. And then also he explained the difficulty EU went through for establishing the system. And in the final part, they explained what the reform package consists of and what is this unitary patent and how does the unified court patent court works. So it's very informative. So we also invited Professor He Tianxiang from City University of Hong Kong to give comment on Professor Sanders' lecture. So now, please, He Tianxiang, Professor.
Thank you,
Welcome,
Shekai.
Tianxiang.
Thank you. So very glad to see Yang here. So it's been a long time that we haven't got a chance to meet each other in face-to-face scenarios.
Too long.
Yeah. So he probably came to visit the Greater China, especially the GBA area, once per year. So he then have a chance to visit Jinan University, but because the COVID, he is not able. Well, you're not able to come to Hong Kong, right? So at least it's open to you. Yeah, probably you need to stay in a hotel for 3 days, but that's it. But very glad to hear about this topic because. Yeah, it's very great to see that you decided to deliver this topic because it's a very timely topic, not just for European Union, but also I think it's for what happens on this corner of China, because that we have Hong Kong, Macau, and we will have to build this Greater Bay Area. So we have been discussing these issues as well. I think that most of the focus is on, because the only place that have this experience is European Union, that, different jurisdictions have different laws, whereas, you want to unify some of these rules in order to promote further harmonization among these regions so that you can promote business, between cities around GBA. So I think that one of the things I learned is that because these difficult scenarios that happens in Europe, that pushes the European Union to develop some of these very smart or hard choices in order to avoid these obstacles, in order to promote further the goal of the single market or whatever policy goals they're aiming for. Whereas, and I also noticed that there are some problems that probably we can avoid because the scenario is in the end is a little bit different. Because we don't have, sovereignty countries in the GBA. In fact, it's two very different jurisdictions due to historical issues that they have different laws and systems. But they want to, or the central government wants to, promote further integration. Whereas I think that some of these things that we can learn from the new movements of the European Union is that probably we can make use of this experience to build like a unified court to handle some of these cases first. But I also noticed that there are some, issues in order to avoid. But based on your experience, Ansam, so will you provide any, insights about these issues? So, for example, if we want to do this like a similar thing in the GBA area, what kind of things we, the most important thing that we need to avoid is what kind of issues that we should be focusing on? I'm very happy to hear from you.
Well, I think that there are several issues. You have to realize that this system was only possible because of an ironing out of issues related to patentable subject matter and patentability. Now, and here you see currently two different diverging paths as well. Whereas Macau simply receives patents that are awarded in Beijing by SNIPA, Hong Kong is moving towards a different system of having fully examined patents for Hong Kong. This is perfectly fine, by the way, but you need to ensure that there is an alignment in relation to what is patentable subject matter and what is not, and what are the policies related to morality and so on. So it's very interesting because you know that I also supervised a PhD written by one of your colleagues in mainland China who discussed the issue of morality of patents in relation to biotechnology. So you need some alignment on that. What are the issues? How do we solve these, etc., etc.? And you have to be very careful about these because it's very difficult to superimpose this. And you also have to look at the needs of the industry in the particular geographical territory. Then there is the issue of language. Although the courts in Macau increasingly operate in Chinese, Portuguese is still an official language of the system. Hong Kong operating in the English language, mainland China in Chinese. That then also means that you have to think of a language regime. And then you also have to be flexible about this. If there is a requirement for translation, you need to ask yourself, when is this truly required? The European solution now is that you don't need to translate everything up front. You need to make sure, however, that for issues of due process, when parties wish to be addressed in their local language, they should be able to do so. I don't know about mainland China. That may even be the case with all the various Chinese local languages. You have to be careful with this if you really want the system to work. So you have language regime issues. And finally, it only works if the judiciary is already willing and able to assess each other's work. How do you operate? What are the reasons for you deciding that there is primary infringement, or whether there is secondary infringement, whether there is infringement by equivalence? How do the rules exactly work? Not just on the statute books, but how do you actually assess a case in real life? And then you also realize that you come from very different positions in terms of rules of procedure. Can you hear evidence? Can you cross-examine technical witnesses? All these types of issues need to be addressed. And then this is really part and parcel of the way in which rules of procedure operate in a legal system. And here you have to also be willing to compromise and to try to understand what the other party is doing. And these are the difficulties that you encounter when trying to harmonize legal systems. It's perfectly possible to do so, but it requires attention to detail, these types of details. And then finally, it's the issue of trust, especially for two parties. Well, in fact, three, of course. But domestically, it's large industry interest versus small and medium-sized enterprises. So the whole effort of this system is also to make the patent system more accessible to SMEs, because it will be much cheaper and you get immediate coverage. I mean, this is really what gets you a loan, because immediately you have access to a much larger market as a patentee. Also, you have to ensure that also foreign undertakings feel comfortable with the new system. So that with this unified patent court and the unitary patent, there has been a lot of consultation, not just between the member states, but also with stakeholders, both domestic, larger industry, SMEs, and also foreign stakeholders. And finally, trust. You only have trust in the system if you have a good judiciary. So the judges that operate in such a system, they really need to be the best. This is true for the legal judges and for the technical judges. So in essence, you need people who have already been operating frequently in patent disputes, and you then also need to ensure that there is a training system in place in order to get new technically judges trained, new legal judges trained, as they develop a new common understanding of patent law.
Thanks, Anselm. So one of the issues I would like to push forward a little bit is that you talk about trust, right? So I understand that, you know, there are so many memberships inside this, agreement. But then there is an issue is that what happens in here is that we have this British, way of doing things in Hong Kong. So therefore, it means that it's a common law jurisdiction versus a civil law jurisdiction. So probably the issue I envisage is that once we sort of build like a similar mechanism, the issue is that if all the judges are trained like in mainland China, then there is a problem. So I think that also happens in Europe. When the British are still there, when you have a court. So did they ever consider that, what would happen if, all of these judges are trained from a civil law jurisdiction, and then if you want to handle these kind of cases, how can you build trust in that kind of setting?
Well, Brexit solved a lot of this, but there are still common law jurisdictions inside of the European Union. Ireland and also Malta and yeah, so you have common law still present. And also, if you now look at the common rules of procedure and so on, there are a lot of common law inventions, especially in relation to enforcement and procedural matters. Another example, it was very common for technical witnesses to be cross-examined, both in the UK system, but also in Nordic systems. I mean, the Nordic system is also distinct from the general common law system. And so in the Nordic system, it was also perfectly acceptable for technical witnesses to be cross-examined. So now in the new system, we have these. It was like, oh, this is useful as a tool. Does it work? Oh, you have experience with this. Let's see how we can integrate this. And then indeed, as you say, the pool of judges is very diverse. Yes, the president of the UPC is Klaus Grabinski, who is one of the top judges from Germany. But there are French judges, Dutch judges, Italian judges. I mean, and the idea that is also present, if you remember that slide that I showed you with the regional and local divisions, that you don't sit in those as purely a national judge. You get somebody from outside, from another jurisdiction to sit with you. So the judges circle, they move from local division to local division. And of course, in the central division and in the Court of Appeal, you have a mixture of jurisdictions. So that is how you build trust. You ensure that these people work together. So indeed, in your scenario, you can't have all mainland trained or all Hong Kong trained. There is no significant patent practice in Macau, but still you need to include in that setting also judges from Macau. And you would need to ensure that they learn from each other by working together on cases if you want to create a harmonized system. That's how you build trust. And I think there is of course a great interest for Greater China to also see how to build trust in terms of what is a prime issue of trade and industry, which is the patent system. And that is, of course, that there is a unique opportunity to engage with a large jurisdiction like Brazil using Macau as a hub. Mm-hmm. Whereas Hong Kong has traditionally performed the function of being an open international trading city based on common law, but really trustworthy rule of law based in trade matters. And I can also then understand the worry that if you were to tinker with this, that trust would evaporate. Whereas mainland China, over time, especially with the specialized IP courts, has built up a great reputation, an increasingly better reputation when it comes to enforcement of intellectual property. So also that you don't want to lose, because there is a positive trust base increasingly in those matters. So it's a very sensitive operation. If you wanted to also to harmonize matters in sort of these three customs territories.
Okay,
So
thank you,
start small.
Yeah. So I think that's something that we are trying to discuss recently among these IP scholars in this area. So another thing is that the European Union, because I didn't see that you specifically mentions that about the database only by, I mean that the database related to patent portfolios, like only by each patent offices of different countries. Did they actually exchange any of this data among institutions, like under the European Union setting? Do they have this? Because that is an kind of an issue in here, because whenever you're talking about these things, it's about, then it becomes a data thing, right? So it becomes, whether this data can be go across border or something, be assessed by a different, jurisdiction or something like that. Do you have similar discussions about these things in European Union?
That context, of course, there was an easy start because the European Patent Office and its databases are public access across jurisdictions. And also the national patent offices of all the participating EPC member states, they also tap into the European Patent Office's database. I think this is in fact a big force, because if you look also in terms of all search engines and all patent analytics databases, they tend to use the ESPASnet database as its primary source. And also with the facilities that the European Patent Office has put in place in terms of machine translation of all patent documents. I mean, this is fantastic. And also the linkages from the EPO to the big five, the other big four, let's put it like that. So Korean Patent Office, Japanese, Chinese, and US Patent Office. That basically means that through this single entry point, you have, through machine translation, access to all this patent information. And it's the most convenient point of access, to my mind, globally. And I think that is due to the fact that the European Patent Office has had to work with a number of states all the time, as opposed to being a single domestic patent office. Now, with the Unified Patent Court, of course, there is also the next step, and that is a data sharing agreement, which has been signed, by the way, between the Unified Patent Court and the European Patent Office. So that also their data management is becoming a shared data management. Obviously, this is to the interest of being able to follow the patent prosecution from the moment of application all the way to the actual enforcement in the courts, and the whole process also before the courts, irrespective where the local division case takes place, because also these local divisions, they're all connected to the centralized division. And this is where Paris is the hub for everything. So all the ICT systems and so on, that's all based in Paris. And I think that then becomes a bit easier because all the data management is EU based, let's put it like that. And within the European Union, we have the legal framework in place to allow for data sharing within the EU context.
Yes, that's why now I understand. It's kind of still going back to sorry, the trust thing, right? So I think you have through all of these years practice using EPO and all sort of these things, I think is no longer an issue because you have already established a lot of corporations and about this data sharing. So what happens here is that whenever people talk about, go across border about this data, then it is always sensitive, and I always understand sometimes you say it is open, it's different that I want to share it with you because you want to download each and every, application without the support of the institution is also very, impossible job. So open means that you can access, but, sharing means that I just open, a port to you, then you can plug in and then you have all these data. That is something different. So I think that means that there are a lot of things we still need to do because to build a trust is not that easy, right? As I see from European Union, it also takes a long time. Even now, I think the
Next
Spanish
time.
people are not trusting you, the new system. The Spanish people, very interesting.
Well, the Spanish people simply wanted Spanish as an official language.
Yeah.
And the distrust is more visible, but you're right there. I think the distrust is more visible in relation to Poland. Although they signed, they do not ratify. And their opinion is very clear. Before we allow these patents to operate in our domestic legal order, we want to know that our national sovereignty is not compromised. And this, I think, says more about the general position of the current government, Polish government, in relation to all matters related to the European Union than this particular system. Yeah, they want to be able to use the patent system for the purpose of domestic industrial policy, very much like what I explained before in the lecture, like the early US patent system or the limitations on the Swiss patent system. The thing is, though, we no longer live in that particular realm. It's no longer possible to have a fully autonomous patent system. And this is, of course, because of the WTO TRIPS agreement. There are certain baselines. And there is a dispute settlement understanding. And we have minimum standards of patent protection. And so the wiggle room, so to say, is much more limited than it was in the past. And this, of course, irrespective of the fact that the dispute settlement is now at the WTO is now stagnant, held hostage by the refusal to appoint new judges. But even that, according to the possibilities offered by the DSU, has been overcome by states wishing to settle disputes. They simply now have indicated that they will utilize the alternative dispute settlement mechanism that the DSU allows for. China included. China and the EU have simply said, we will not, if we have a dispute, we want that dispute to be heard by a rule-based international arbiter. Yeah, that I think that shows also a level of trust still in the international trading system. Now, how this is going to develop in all the, with all the geopolitical tensions, everything becomes fluid, of course, but nevertheless, there is still this commitment to the rule-based international trading system.
Okay. Thank you, Professor Sanders, and thank you, Professor He, for introducing a very interesting and practical discussion from the perspective of GBA. Okay, so also what we can learn from the EU if we want to enhance the cooperation between mainland China, Macau, and Hong Kong. And let's see, is there any questions from our audience, from students? 各位同学，有没有什么问题想要提问的呢？ Okay, if there's no any question, I will use my privilege as a moderator. Actually, I'm more of a copyright guy, so I'm not very specialized in patent system. So I have one question. I'm interested in one question. Does the national patent system still exist after the system unitary patent system come into effect in 2023? if a Chinese company want to apply a national patent in Germany, is it workable?
Yes, it's still possible. Those systems will coexist because also it's a question of choice and a question of cost. So if you wish to obtain a patent in Germany alone, you can even apply directly to the German Patent Office. Okay. And not engage the European Patent Office whatsoever. That still remains the case. The question is, of course, over time, whether these national patent systems will continue to exist. And that very much depends on the success of the unitary patent and the unified patent court system.
Okay, so for now, it's like two parallel systems that work together. Okay.
Well, in fact, even three. So you can apply for a domestic patent to a domestic patent office, the German patent office, French patent office, Dutch patent office. You can all go there. You can also apply for a European patent with the European Patent Office. The European Patent Office will do the examination and grant, and then you can get a bundle of national patents that are valid only in the member states. Or in addition, you can apply for a European patent with unitary effect, which is the new system. So you have only more options rather than fewer.
Okay, thank you very much for your answer. So, Professor He, do you have any further comments or questions?
No, not really. I already asked all my questions.
Okay, so thank you very much for Professor Sanders for this wonderful lecture. And I'm sincerely sorry for the mistake I made as to the time issue. So actually, our Jinan University is going through the very difficult time because the campus is was actually locked down yesterday because there was one positive test result. So all the students are now in quarantine in their dormitory. So thank you very much for giving this lecture and then let their students have something to learn even under this difficult situation. And so in the end, I want to welcome Professor Sanders. If in the future and we open our border again, welcome to visit our campus and Professor He Tianxiang to join us and meet in person. Thank you very much.
That is always preferred. Thank you very much. And I hope indeed that in future China's borders will reopen. It's much better to meet in person. Okay.
Yeah.
Thank you very much.
Okay. See you.
And see you. Bye-bye.
Bye-bye.
Thank you. Bye-bye.